very much, Ravi. It's a pleasure to be with you all today. And like Ravi said, I'm happy to take any questions. I am the chair of our intellectual property practice. Have been doing that for quite some time now. And our practice, we've been practicing intellectual property law at this firm since the early part of the 19th century. So we're really well positioned in that particular area of law, have a long and rich history of helping innovative companies deal with complex IP issues, including disputes. So let's start with some basics, and then I'll dive into some specific examples, focus a little bit more on the patent side of it down a little later in the talk. That's my area of focus, and I find it rather interesting, as you might imagine. So when we talk about intellectual property rights, we are referring to four fundamental types of property. Ravi mentioned patents, trademarks, copyrights. I also include trade secrets, and I'll talk a little bit about that as a component of what you would consider your suite of intellectual property if you're a growing entity. Patents protect inventions of all types, including devices, electronics, processes, chemicals, and pharmaceuticals. Those are just examples, or even other types of patents that you can pursue. Trademarks is the next category, which protects brands. And trademarks are designed to identify the source of the goods or services that are being offered by a particular entity. You have copyrights. Copyrights protect artistic impressions, such as books, screenplays, music, and increasingly software. Software can be protected, particularly the code, by copyright protection, as well as the manifestation of the code, like the visual appearance of an interface. And then there are trade secrets. Trade secrets, as the name implies, relate to secrets or information that is kept confidential. So a trade secret protects any aspect of a business so long as it is kept a secret and adds economic value to the business. All right. I mentioned that patents cover all types of inventions, but it's a common misunderstanding that if you get a patent, you get to do exactly what's described in the patent. The actual property right conferred to a patent owner is the right to exclude others from making, using, selling, or importing the invention. And there's a nuance to that. We'll talk a little bit more about it. Some basic things that you should know about patents include that a patent protects an invention for 20 years from the date of filing. It's a very powerful tool. In virtually all countries around the world, patents are awarded to the first applicant to file for the invention, even if somebody else invented it first and didn't pursue patent protection on it. So that it's important, if you are pursuing an invention, to act quickly and get the information to the relevant patent office. The policy behind patent rights is to promote innovation, and the patent applicant is required to disclose all aspects of the invention so the public can read and understand the invention and potentially improve upon it. So that's the promotion of innovation. In exchange for that disclosure of information by the applicant, the government grants this limited monopoly right as a reward. That's the 20-year term of the patent. And unlike other types of intellectual property, one can innocently infringe a patent. In other words, even if the infringer had no idea that the patent even existed and just happened to trespass upon it by creating a device that is infringing the patent, he or she can be liable for infringing it. You probably recognize this particular device here. Our firm represents Apple, and we've obtained numerous patents covering the Apple Watch depicted here and other Apple devices as well. There are literally hundreds, if not even thousands, of inventions that reside within this particular device. And each one pretty much needs to be pursued as an independent and individual patent right. Okay. Trademarks. As I mentioned, trademarks cover brands and are source indicators. Trademarks can cover words, symbols, designs, and even physical objects. So when you drink a Coca-Cola anywhere in the world, and these are two of the most recognizable trademarks around the world. When you drink a Coca-Cola, you have an expectation of its taste. And the Coca-Cola company, which owns these trademarks and produces the beverage, guarantees that that taste will be consistent across the world. And that they do that through offering their beverage using these very strong brand indicators. One of the proud legacies of our law firm is a man named Harold Hirsch, a former partner of the firm who represented the Coca-Cola company way back in the early 1900s. And at that time, the drink was being bottled, but it was being bottled in a variety of different shaped bottles, depending on whatever the bottlers could find. And there was a lot of confusion in the market as to what drink was a Coca-Cola. There were some competitors out there that were trying to copy it. And Mr. Hirsch advised the company, if you think about it, in the early 1900s, there were refrigeration devices. I think they called them ice boxes, but there were no lights in them. That was a feature that was not available at the time. So he advised the company that they should create a signature bottle, one that could be recognized in the dark of night by touch when you reach your hand into an ice box. So they took his advice and developed a bottle design, and that bottle design is now widely recognized as the Coca-Cola bottle. And he had the wherewithal to not only understand its value as a business tool, but also sought registration of that bottle design as a trademark, arguing with the trademark office that the shape itself was an indicator of source, and was able to register the first ever physical object with the United States Trademark Office. Okay, copyrights. Copyrights protect original artistic expression reduced to a tangible form, and owning a copyright prevents others from reproducing, distributing, publicly performing, displaying, or even developing derivative works from your copyrighted material. And I mentioned software at the outset because when you hear the words artistic impression or expression, you don't typically think of software. But believe it or not, two of the largest copyright cases that have ever been filed in the United States were software related. One was between Apple and Microsoft relating to the graphical user interface that those two companies developed. And one was between Apple and Google relating to operating systems that underlie mobile devices like Samsung or Android and Apple and iPhones. And then trade secrets, as I mentioned, are another form of intellectual property, probably not quite as well known, but trade secrets protect any secret formula, pattern, device, compilation of information, or any type of business information used by a company that gives it an advantage in the marketplace over its competitors, and it has to be actively protected. Trade secrets can be extremely technical in nature, like a chemical formulation or process that leads to a very complicated technological result, or it can be as simple as a customer list, but it does need to be something that is kept secret and generally speaking under lock and key, like computer password protected, or in the case of the Coca-Cola formula, which is probably the most famous trade secret in the world, it does physically reside somewhere in a vault, I believe, in a Truist Bank location. Only a few people know where. I can proudly say that my firm helped protect it over 100 years ago. Again, the esteemed Mr. Hirsch, recognizing the importance of the recipe to the business, counseled them on how to keep it a secret rather than protecting it through other ways or risk its loss. And that still today is a very significant asset for the Coca-Cola company. So some things you should know about intellectual property, or sometimes referred to as intangible assets. is that in the context of corporate valuations, IP rights really tower above other categories. In a study that's done about every decade, most recently in 2019 by the risk management firm Aon, it was estimated that the value of the intangible assets within the S&P 500 was $21 trillion, and the value of the tangible assets was only $4 trillion. If you move the time frame back, these same figures when the study was performed in 2006 were 9.28 trillion for the intangible versus 2.32 trillion for the tangible assets. And even back in the dark ages of the 90s, the ratio was 2-to-1 intangible asset value to tangible asset value. And then this time frame has also resulted in a pretty significant changing of the guard, with the most capitalized companies in the 2006 timeframe being companies like GE and ExxonMobil, who have a lot of physical assets. They have plants, they have building equipment. If you think of ExxonMobil, they got a lot of oil drilling equipment. And more recently, with the emergence of the digital economy, those firms that are most capitalized are now companies like Alphabet, Amazon, Microsoft, and Facebook, or now Meta. So pretty substantial shift. So the policy behind patent rights in particular is to aim to increase private research and investment in new technologies. It's the reasoning behind that is really to allow inventors to capture a higher share of returns on their inventions if they didn't have that right. So by offering them some value through patent protection, you're going to get more disclosure of information that the public can take advantage of. And by establishing a regime in which inventors can earn extra competitive profits for a limited amount of time, that's that 20 years, which is the term of the patent, the system aims to allow inventors to recoup their R&D expenditures and hence provide incentives for such investments and disclosures through the patent system. And while patents are essentially industry agnostic, the healthcare industry in particular, the pharmaceutical industry, is said to be a very big proponent of a strong patent system. Pharmaceuticals are very expensive to develop. They require years of R&D in order to get to a finished product and then FDA approval beyond that. And some patented drugs have margins as high as 90%, taking advantage of the exclusivity afforded by the patent protection. And studies also indicate that once these drug patents expire, lower priced generic drugs flood the market and very quickly replace up to 90% of the sales. This phenomenon has been referred to as a patent cliff. One famous drug that you guys probably aren't familiar with, but people my age certainly are, is Lipitor. It's a cholesterol reducing drug. It was produced by Pfizer, and that drug alone reached $12.9 billion in annual sales and accounted for 27% of Pfizer's revenue, which Pfizer is a very substantial company and develops a lot of different drugs. But that particular one, while it was under patent protection, was extremely profitable and important asset. When we talk about policy as lawyers, we often try to find the genesis of that policy through the Constitution. And in this case, for patent and copyright, the genesis of the policy comes from Article 1, Section 8. And this clause says to promote the progress of science and useful arts. The science is referring to the patents and the inventive arts, and the useful arts being the more artistic impressions. So to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And so the reason the Constitution empowers Congress to grant these exclusive rights, again, is to promote the progress of innovation, science, and the useful arts. And those grants are in the form of these legal monopolies. if you think about it, they're a little bit of a departure from the capitalist economic system that typifies American business, because they create this ability for a patent owner, a copyright owner to have a monopoly. But despite some of the criticism, of that, it is a system that has been widely recognized to promote progress. And stronger patent systems around the world are often indicative in different countries of economic progress. And it's hard to not to agree that the result of the R&D that is undertaken by the pharmaceutical industry has resulted in significant scientific progress with respect to healthcare. The exclusivity, I'm going to go back to this issue, is in the form of a right to exclude. So if you're a patent owner and you don't practice the patent itself, that doesn't mean you don't have a right. You still have the right to prevent others from practicing the invention. And so here's one way to think about it. If you go way back to when bicycles were invented, and you think about the first ever bicycle that was invented, and let's assume that that inventor pursued a patent on the bicycle, and they had come up with a way to describe their invention, and it was limited to a very basic bike with a frame, two wheels, pedals, and handlebars. That would be a very effective and innovative tool to get you from point A to point B. But in order to stop the bike, you'd have to use your feet or otherwise risk crashing the bike or somehow slow it down, because there were no brakes that had been presumably invented or described in this patent. And so inventor two, seeing this device and recognizing its utility, determines that that's a great invention, but we really need a way to stop it. So they develop a braking system, right? And they seek a patent for a bicycle with brakes. So they describe, essentially the same bike components, the frame, the two wheels, the pedals, and the handlebars, but they also add a braking system to that device. And now, not only can you stop the bike, you can change the bike configuration, for example, to this one on the left where the rider's feet wouldn't even touch the ground. They could still stop the bike. It creates other options for bike manufacturers. But the inventor number two would still have to seek some license of some sort from inventor number one that owned the patent on the basic bicycle, because the bicycle with brakes still has all the components of the basic bicycle. So that's why it's a right. So inventor one that has the very basic bicycle patent without the brakes on it, which, as long as it was within the 20-year term of that patent, would have the ability to exclude bicycles with brakes, because those bicycles still had the core components of his or her patent: the frame, the two wheels, the pedals, and the handlebar. So it's a complicated concept for many people. Colloquially, people think that if you get a patent, you can do whatever is described in your patent. It doesn't quite work that way. But a patent is a very powerful tool because it can be used to exclude others from doing what's described in the patent itself. So I've touched on this a little bit, and it's really a fundamental issue of the system. There is a quid pro quo. And in exchange for the right to exclude others, this monopoly right, from making, using, importing, or selling one's invention for a limited period of time, the limited monopoly, you must fully disclose your invention so that the public can benefit from understanding how it works, how it's made, and how to improve upon it. And the reason for that is to teach those of skill in this particular area of technology how to make and use the invention, and also to inform the public of the boundaries of the invention. So if you see a patent, you understand how it works. If you figure out a different way to do it, then perhaps that you can get around the patent, and the patent needs to very clearly describe what it is the inventor has invented and what it is that is being protected. All right. Getting a patent involves conducting a patent search, preparing a detailed patent application, filing it with the appropriate patent office, and waiting for the patent examiner to review and otherwise communicate with the applicant regarding whether the patent application is allowed. Typically what happens is the patent examiner does a search also and identifies some prior technology that is overlapping with the patent application and pushes back. And the patent applicant then typically through argument with the patent office or amendment of the patent application will try to convince the patent office to issue the patent by making some changes or making some arguments as to why the patent should issue. The process is complex, it is time consuming, and it's often helpful to consult an attorney, although it's not required to do that. The patent application should again describe the invention in detail, how it works, and what's particularly unique about it. And a really well-drafted patent application will also explain, why it is valuable, why it is improving upon what's been done before, or otherwise benefiting someone or society at large. And the goal of obtaining a patent is to protect the invention and give you, again, the exclusive right to profit from it, regardless of whether you are practicing the invention or somebody else is. A United States patent is presumed to be valid once it issues, and that's a really powerful presumption. This is because the United States Patent and Trademark Office will have performed its role as an agency of the U.S. government to examine the application, perform a search as to what's been done before, and determine that it should issue. And so that means that the patent, once it issues, has the stamp of approval from the U.S. government, and therefore, from an evidentiary standpoint, is presumed to be valid. And what happens is when patents are litigated, when a patent owner sues someone else for patent infringement, there are generally two defenses to that type of case. One is non-infringement. In other words, I don't do what's described in the patent. What my device does or how it operates is slightly different or substantially different than what's described in the patent. The other defense is even if I do exactly what's described in the patent, I believe the patent's invalid because somebody else had invented it beforehand. And it's that second defense, the invalidity defense, that is subject to this presumption of validity. And what that means is when you're raising that defense as a defendant in the court of law, you have a very high standard to meet. That standard is known as clear and convincing evidence. And it's been described as similar to the beyond a reasonable doubt standard in criminal cases. So it's very high. It's not just a 51% chance I'm right. It's a very high standard. You have to really prove, again, by clear and convincing evidence, that's a very substantial threshold, that what's exactly described in this patent has been done prior to the applicant ever applying for the patent. So you have to go back in time, you have to develop evidence. That evidence has to be very compelling, and it needs to come forward and be presented in a way that meets that clear and convincing standard. And the way patents are tried in the United States is no different than any other type of trial. I think a lot of lay people are very surprised by that. These can be very technical cases involving devices like Apple Watches and how they work. And if you think about the complexity of all the functionality within an Apple Watch, if you have a case on that, you have to delve very deeply into the technology. But then we're talking about conducting a jury trial. And a jury trial is before 12 ordinary people trying to make a decision on the outcome of this very complex case. So there's a lot of choreography that goes into it, a lot of themes that you have to develop. At the same time, you have to stay true to the technology. You have an obligation as a lawyer to the court to not cut any corners. And so it's a pretty interesting puzzle that you're trying to solve. And I just have a short clip from a video that's often shown to jury members. I've just taken the 30 seconds of it that I'm going to play just to give you a sense of, if, for example, your aunt or uncle who has no technical background is sitting in a jury on a patent case, this is something that they might hear.
How can I sit in judge for a case like this? I'm not entirely sure what a patent is. We hope to answer that concern in this brief video, give you some of the background. This case involves some special issues that the judge and lawyer can explain, but all patent cases involve some basics. This video will discuss what patents are, why we have them, how people get them, why there are disputes that require us to call in a jury like you.
So that probably gives you a sense of how people that are sitting in judgment of patent cases have very little understanding of the system, probably less than you all will after the end of this 45-minute session. And they're going to be making a decision that could have ramifications worth millions, if not hundreds of millions, and even billions of dollars in some cases. So it's a pretty interesting system in that regard. And as a lawyer that takes patent cases to trial, it's part of the challenge to really deliver the information at a level that meets our obligations to the court, but at the same time is intelligible to the average juror. So I mentioned patents are examined by the U.S. Patent and Trademark Office, and they're examined by a patent examiner who has perhaps some familiarity with the technical subject matter. It's not like a juror. These people are hired because they have some technical training of some sort. So they understand the subject matter of the patent. For example, if you have a semiconductor patent versus a bicycle patent, it's going to go to two different types of examiners with different understandings of technology. The examiner does a search. They are government employees. They have a limited amount of time and resources in which to conduct this search for each application. And the bottom line is that the examiner cannot do an exhaustive search of everything that might have existed before this patent application was filed. And so they often issue a lot of patents that later are found invalid. But again, that presumption of validity is so substantial, it makes it difficult to prove that a patent's invalid. Nevertheless, there's always a defense that's raised in a patent case, and it's a pretty big part of a patent trial. Unlike Europe, patent rights are granted in the United States are subject to a strict territoriality limit. That is, a U.S. patent is only enforceable against activity that occurs in the United States, with one exception, and that is one of the rights conferred to a patent owner is the right to limit importation into the United States, infringing devices. So even if something's manufactured outside of the United States, for example, Europe or China or anywhere else in the world, and it's being imported into the U.S., then as a patent owner, you can prevent that from happening. But otherwise, if, for example, you have a U.S. patent and you notice that someone's infringing it in Germany, and you don't have any evidence of any connection of that activity, that infringing activity in the United States, they're not offering the product in the United States, they're not present in the United States, you don't have any evidence that any of those devices have ever been imported in the United States, then your U.S. patent will not do you any good. And one thing that you should understand is patents are property rights, just like other types of property rights. You think of property rights as, the home that you might live in or a car that somebody owns. Well, a patent is a piece of property. It's referred to as intellectual property. But since it's a piece of property, it can be transacted. For example, you can license patent rights to somebody else. So you can if you own a patent and you see somebody that's interested in developing the technology, you can license that right to them. You can also sell a patent. Patents are often sold. In fact, about 20 years ago, coming out of the dot-com boom, there were a lot of patents that had been applied for and issued at that point, and a lot of these companies did not survive. So there was an active marketplace for patents, and many patents were transacted about that time, and they were sold. And shortly after that time frame, there was really a pretty substantial increase in the amounts of patent cases, litigation that was being filed, because a lot of these patents were bought by very entrepreneurial folks that didn't have any intention of practicing the patent. In other words, selling products that were covered by the patent, but rather using the patent as a tool to license others and leverage the litigation process to do that. And so an industry phenomenon was born. We refer to those entities as non-practicing entities. In other words, they're not practicing the patent, they just own the patent. But more pejoratively, they're referred to as patent trolls. If you think of what a mythical troll would do when someone was crossing a bridge, ask them for a toll to get across. And that's the metaphor there, where a patent owner has no intent to ever produce the invention. Let's go back to the very first bicycle, but they want to prevent other people who are developing bicycles from doing so without paying them some licensing fee. So that is essentially the concept behind patent trolling. You guys probably are not familiar with this device, but if it is a BlackBerry, and it predated most smartphones, particularly iPhone and Android devices. And back in the day, it was extremely popular. It was a very, very substantially adopted piece of equipment. And for those of us who had a pretty deep relationship with the BlackBerry, we still kind of lament the loss of the keyboard, which was really a phenomenally useful little device for emails in particular. And I still think the keyboard's probably far superior to what we have today. But the story here is that it was extremely widely adopted, and a company called NTP had developed a lot of patent rights on remote email systems. And so they wanted to go out and leverage those patents for licensing fees. And so they sued Research in Motion, the maker of the BlackBerry device. And they sued RIM in the United States District Court for the Eastern District of Virginia. And that court is really well known for its strict adherence to timetables and deadlines, and sometimes referred to as a rocket docket because it moves so fast. And it's really efficient in trying patent cases. During the RIM trial, the NTP, again, was a patent owner, and RIM, or Research in Motion, was a defendant. And they were kind of dead to rights on infringing these email patents owned by NTP. So they tried to focus on whether those patent rights were valid. And they did a lot of research and analysis on prior email systems, and they found one. They found one that was very, very close to what was described in the NTP patents. In fact, so close they thought essentially identical. It was called System for Automated Messages, or SAM. And that case went to trial in this very fast docket. And at trial, the RIM defense team put a demonstration together for the jury, and they were showing how the SAM system worked and how it was exactly like these patents that were being asserted against RIM by NTP. But during that trial, the NTP attorneys, with a very effective cross-examination, found out and were able to show the jury that while the system worked just like the patents that were being asserted, the version of the software that RIM was using for its demonstration was a later version, and that version did not predate these patent applications. And so maybe there was some evidence, maybe that software hadn't changed at all, but that hole in the defense in RIM's story, and the version of the software not predating these NTP applications was enough so that it did not meet that clear and convincing standard. So the judge threw that evidence out, and that case went to the jury. Eventually, RIM was found to infringe those patents. Not only were they found to infringe, they were found to have willfully infringed them, because apparently there was also some evidence that they knew about the NTP patents and didn't attempt to take a license, and just pursued their device and the functionality within it in what the judge referred to as reckless behavior. So that's like a punitive. So they were hit with some punitive damages, and in fact, were forced to pay NTP's legal fees. So that case went up on appeal, and in something, this is very uncommon, the solicitor, which is the government's attorney, filed a brief on behalf of the U.S. government during appeal. And that brief, primarily on for the benefit of the Department of Defense, suggested that this particular device was so important to the government, that so many government employees were using it, that it was actually important to our national security, and that the court should not, if it not issue this injunction preventing RIM from selling this device, or if it did, it should carve out the U.S. government, which again, that kind of argument is very, very rare, and in fact was not effective. RIM was under a lot of pressure to get this case resolved. Things were not looking good for it in its appellate strategy. And eventually they settled, and they settled for $612 million in order to be able to continue to produce this particular BlackBerry device. And think about it, that was in 2006, and then like a year and a half later, the iPhone comes out, and they paid all this money, and essentially the technology moved very quickly beyond what the BlackBerry had to offer, and the device was essentially obsolete about 4 years later. So pretty interesting story, but it gives you an idea of how valuable patent rights can be, even if NTP in this case never really made a whole lot of money on any kind of email system that they produced. They were able to leverage their patents so that they got the very big payoff because somebody else was infringing their patents. The Constellation cases were something that I was actually involved in. About that same time, our firm was defending a case brought by a company called Orion against numerous automotive OEMs, or original equipment manufacturers. Our clients in that case were both Chrysler and Mercedes-Benz. And Orion had been formed by an enterprising lawyer who had bought a dozen patents out of auction for about $1 million, a guy named Eric Spangenberg. And these patents related to database structures and website that underlie websites. And they essentially, the Orion patent accused the websites of all of these auto manufacturers of infringing based on functionality that allowed you to pick and choose what model vehicle you were interested in, what features you were interested in, what colors maybe, and then put it all together on your screen so that you see a visual impression of what you selected, like a virtual brochure, so that you didn't have to go to the dealer and pick up a physical brochure anymore. You could see all that stuff online. And so the case was litigated very vigorously. It had been filed in the Eastern District of Texas, which was a notoriously plaintiff-friendly jurisdiction. And so all of our clients, the automotive companies, realized that they had a tough hill to climb to win this case. But we pushed back a lot. Eventually, those cases settled. And they settled because the car companies recognized how difficult it is to win a trial like that in a place like the Eastern District of Texas. And they were very concerned about having their websites shut down because it was a very important tool for them to sell vehicles. But shortly after they settled, within a year, Chrysler and Mercedes were sued again by a company called Taurus. Totally different patent, and we were retained again to defend them. And this time the case was filed in Wisconsin. But otherwise, it had a lot of similarities to the Orion case. And it was really the same website functionality, the virtual brochure technology that was accused of infringement. This patent was a little bit more database focused. We did some digging. That's what you do as a lawyer. You gather a lot of evidence. You take a lot of discovery. We found out that this patent had also been purchased by Eric Spangenberg, and it was purchased as part of that original auction packet that he had bought for roughly $1 million. And he had made way more than $1 million in the settlement of the Orion cases. So, our clients were very upset about this, about getting sued twice. And this time decided, hey, we're going to take this case to trial. We're not going to be an ATM for this guy. He's not going to, every time he buys a new patent, going to knock on our door and we're going to write him a check. So basically, you better win this case. So we were able to raise not only your typical defenses of non-infringement and invalidity, where we actually invalidated that Taurus patent, but we also raised a breach of contract claim under the settlement agreement, where our clients had obtained a license to not only the patent that was issued, that was asserted in the Orion case, but also any other related patent that had ever been owned by Orion or any related entity or owner of Orion. So we had to do a lot of digging, and we again connected all this stuff through a series of documents that we found to this guy, Eric Spangenberg. We were able to paint him as the mastermind of this particular constellation case approach. And we were able to win that case, and not only win by invalidating his patent, but also obtaining the fees for litigating that case from Orion, from Taurus, I should say, and ultimately Mr. Spangenberg. And Ravi, I know we're right about out of time. I got one more example, unless you want me to take questions.
I think we do have a couple questions,
Okay.
but if you think this example would be more helpful, are you
I'll give it to you in 1 minute, and then I'll take a question. So going back to the Apple Watch, because we talked about it earlier, in 2022, Apple sold 49 million smartwatches or Apple Watches, but they were sued in 2023 by a company called Masimo for infringement of 10 patents related to an oximeter or oxygen sensors in the watch. They've lost that trial. Apple's as sophisticated as they come in terms of defending these types of cases. They tried to invalidate the 10 patents. They were unable to do that. They had to redesign their Apple Watch. It's the Apple Watch version 9. They had to disable the oxygen sensing features in order to have those devices pass through customs. That case is on appeal. It was a pretty substantial loss for Apple, and kind of hurt them in the marketplace from a reputational standpoint. I mentioned that this device, however, has hundreds of, if not thousands of inventions within it. So it's certainly still a viable device, but it is currently being sold without the oxygen sensing feature because of that patent case. So again, just to give you an idea of the power of patents.
Awesome. We do have a couple questions.
Sure.
So the first one is from Rashab, wondering if copyrights apply to AI generated items.
Yeah. Okay. Great question. Yes, they absolutely do. And so one of the real tricky parts about AI generated items or copyrighted AI generated materials, typically people come to lawyers like us and say, can you give us an opinion on whether this infringes somebody else's copyrighted work? And in which case we can say it's a screenplay or something. We can read it. We can compare it to what's, we know of that's been done, what the the basis for the screenplay was, where the author kind of derived his or her inspiration, and apply some legal judgment to it and give an opinion. In the case of AI, we don't know what the bot used to develop that screenplay, and it's really hard for us to make that assessment because the underlying process by which that screenplay in that example was developed is unknown. So yes, you can certainly infringe someone's copyright just by generating material through artificial intelligence. And it's also very difficult to know if you are infringing someone's copyright or not.
Awesome. And then another question has to deal with some of the research that we do in policy debate. So this year's topic regards strengthening our protection of domestic intellectual property rights. Do you know of any resources that often publish, articles or journals regarding this type of information?
Yeah, there are quite a few scholars. I mean, a lot of that stuff is written through law review articles from law firms. There are also some think tanks out there and some organizations, like the ones that I'm familiar with is IPO, Intellectual Property Owners. That's what it stands for. That's what the acronym's for. And AIPLA, American Institute of American Intellectual Property Lawyers Association, AIPLA. So those are two places where you see a lot of thought leadership in terms of legislation and other activity related to strengthening IP rights.